Good morning, everyone. Thank you so much for coming to our panel today. My name is Dr. Talita Diaz. I am Senior Research Fellow in the International Law Program at Chatham House, or the Royal Institute of International Affairs. And it's my pleasure to chair this panel on the state of play of collective countermeasures after Russia's aggression towards Ukraine. A very hot topic indeed, both in cyber policy, cybersecurity, and also international law. Just to introduce the topic a little bit for those who aren't familiar with it, countermeasures are one of the various response options that states have in their accountability toolbox to respond to a range of malicious acts, including in cyberspace. But unlike other response options like retortion, diplomatic measures, countermeasures are measures that would involve a breach of international law that is justified in the circumstances because it's a response to an unlawful, internationally wrongful act. Now, it's now uncontroversial that under customary international law, the unwritten rules of international law, states can resort to countermeasures in response to internationally wrongful acts, including in cyberspace. So malicious cyber operations that amount to unlawful acts. So that's uncontroversial. Many states have issued positions on this, reaffirming this, and there's really no controversy about that. And states can use cyber or non-cyber countermeasures in response to these malicious cyber operations that violate international law. Now, countermeasures, they're subject to a range of very strict substantive and procedural conditions that resulted from very difficult negotiations and compromises between states. And these conditions, they seek to reflect a very delicate balance between, on the one hand, avoiding abuse, right? Because there is a risk of conflict escalation if you use countermeasures, if you breach international law to respond to a breach of international law. But on the one hand, one also must consider the rights of the state injured by a breach of international law to redress that harm. So it's a delicate balance there. And these conditions include, for example, the fact that responses need to be proportionate to the initial wrongful act. The state that is injured by a breach needs to target countermeasures towards the responsible state, not third parties. There's also a question of whether or not the state injured by a breach needs to make some sort of prior demand to the responsible state to stop the wrongful act. So there are all these conditions that are well grounded in customary international law generally, but in cyberspace, there's new and old debates have reemerged, and they have gained traction in the cyber context because of certain operational features of cyber operations. So, for example, cyber operations are very quick. They are covert most of the time. They have widespread consequences. And so these features, they don't sit easily with the traditional features of wrongful acts that we see in other contexts, such as in the global economy, for example. So that has generated a lot of debate. And one of these hot topics that is the object of much debate is precisely collective countermeasures, which we will discuss today. So that's the question of who can take countermeasures, which states can take countermeasures other than the state that is directly or individually injured by a breach of international law. There are different types of collective countermeasures that have been discussed in the literature and among states, and views are very divided, as our wonderful panelists will touch on this issue. But just to give you an overview, we've got what we call general interest countermeasures that respond to a breach of a collective or a community obligation. For example, a breach of the prohibition on the use of force and aggression, what we call erga omnes obligations, right? So these are one kind of collective countermeasures. On the other hand, we have what others have called proxy countermeasures, and these are measures that are taken by states that are in no way particularly interested or indirectly interested or affected by the breach. So the obligation is not a collective or a community obligation, but the injured state requests assistance from third states to help, and so that's why we call them proxy countermeasures, because the third state comes to help and acts as a surrogate for the injured state. So that's just an overview of the topic. We also have the issue of aid or assistance when a third state helps the injured state without taking countermeasures per se, but just providing assistance. So that's really the overview, the different legal concepts that we're going to discuss. And we have three wonderful panelists to discuss this issue today. So right next to me, we have Professor Jeff Kosseff, who is Associate Professor of Cybersecurity Law at the U.S. Naval Academy. Professor Kosseff has just published his fourth book, Liar in a Crowded Theater, Freedom of Speech in a World of Misinformation. And before joining the Naval Academy, he practiced First Amendment and cybersecurity law in Washington, D.C. Thank you so much for being with us today. Next to him, we have Lisandra Novo. Lisandra is a staff lawyer for the Strategic Litigation Project at the Atlantic Council, and previously she was a judicial fellow at the International Court of Justice and also a visiting professional at the Inter-American Court of Human Rights, and she has worked previously on civil U.S. litigation for gross human rights violations committed abroad, and she also served as a Fulbright Scholar in Spain. Right? And last but not least, right next to Lisandra, we have Erki Kodar, who is Undersecretary for Legal and Consular Affairs at the Ministry of Foreign Affairs of Estonia, where he directs the work of the Legal Department and the Consular Department, and he advises the Directorate and Structural Units of the Ministry on legal and consular issues, including issues of international law. And before joining the ministry in 2019, he worked in the Ministry of Defense as Undersecretary for Legal and Administrative Affairs, Director of the NATO and EU Department, and Director and Lawyer of the Legal Department. A lot of stuff, Erki. And then prior to that, he was also an adjunct lecturer at the School of Law of the University of Tartu here in Estonia. So basically, just to give you an overview of how we're going to organize this panel, we're going to try to have a more dynamic discussion among us, also touching on the brilliant papers that both Jeff and Lisandra have written, which you can find in the CyCon book this year. Please read their excellent papers. So we're going to have a little discussion among us, touching on fleshing out all these controversial issues, and then there will be an opportunity for a Q&A with the audience. Okay? So I'm going to start with you, Jeff, if I may. And you've written an excellent paper entitled The International Legal Framework for Hunt Forward and the Case for Collective Countermeasures. Can you tell us a little bit about what the paper's key arguments are, and in particular, can you lay out the case for collective countermeasures?
Sure, I'm happy to, and thanks for having me, and I just have to give the disclaimer before I start that everything I say is only my point of view, and it doesn't represent the Naval Academy, the Department of Navy, the Department of Defense. Nobody else wants to take responsibility for what I have to say. So having said that, hunt forward and collective countermeasures are two areas that I've really been interested in with my research, and you wouldn't necessarily think that they were related when you first look at them, because hunt forward is something that's been the U.S. Department of Defense Cyber Command has had as an initiative for about 5 years now, where cyber protection teams from the United States, at the request of a partner nation, visit and sit side by side with the partner nation on a strictly defensive basis to hunt for malicious activity and to provide advice and assistance to the allied country. And it's really a win-win-win, because what it does is it first helps the ally figure out how to eliminate certain threats from its network. It provides the United States with valuable information that might be useful for our own defense, and it also benefits the private sector because, for example, the United States releases a lot of the malware that it finds, or the samples, so the private sector can deal with it. So it's really successful. I want to be clear that collective countermeasures are not necessary to justify hunt forward, and this is all based on all of the public statements about hunt forward. It's strictly defensive. But the reason why I started thinking about collective countermeasures is, first, it's been an interest of mine actually since 5 years ago at this conference when I saw the president of Estonia make the case for collective countermeasures here. I've written about it, and I've also been really interested in all of the international legal issues that are sub-use of force and armed attack, because I feel like that's really where a lot of the very interesting and important imminent questions are coming from. So what I was thinking about is the collaborative nature of Hunt Forward and how valuable it has been, and how could that model be expanded. And a logical way to expand it is to go beyond strictly defensive to look for other partnerships. And that would raise much more difficult international legal issues. So I think that the collaborative nature and the success of Hunt Forward helps to justify at least an argument for why, from a normative view, collective countermeasures should be considered more thoroughly as other states are developing their legal positions on the topic. So that's really what prompted this to look at, and they've gotten the name collective countermeasures. I almost would like to see it be collaborative countermeasures. And when you talk about, and we can talk about this later, the different types of countermeasures, I think one logical starting point would be the proxy countermeasures, where just as with Hunt Forward, where it's an operation that's done clearly by the invitation and consent of the injured state, the same thing could possibly carry over to countermeasures that are done collaboratively.
Great. Thank you so much, Jeff. And Lisandra, you've also written a paper precisely on this topic, laying out different arguments, but also touching on the issue of proxy and collective countermeasures more generally. So your paper is entitled Specially Affected States, Push for Collective Countermeasures. And in your paper, you talk about this concept of specially affected states and how it plays out in this context of collective countermeasures. So could you take us through the key arguments that you make in the paper, especially who you consider to be especially affected states in this context, and why, in your view, these states should support collective countermeasures?
Yes, absolutely. Thank you as well for having me on. I have to start already with definitions. The title already has legal terms. So I want to start with first kind of my thesis, which is that we're looking at possibly the emergence of a new norm in international customary law. What are all these words? So as Talita said, customary international law is the unwritten rules of international law that are binding on states. How do you figure out what a rule is if it's unwritten? So here is where you have to come into how to identify customary international law. And there's two factors at play here. One is state practice. What are states actually doing? The other is opinio juris. What do states think their legal obligations are? And again, as Talita mentioned, in this context, it's pretty hard to assess state practice because so much of it in the cyber context is not public. And so opinio juris weighs really heavily here in terms of what do states think their legal obligations or rights are. And so here, again, identifying what a new norm is it's a difficult job. There's no magic number of states at which something becomes a new norm. It's not 123 UN member states do this, so now we have a new norm, right? The practice has to be extensive, and this means it has to be widespread enough that you can deduce this is really viewed generally as an obligation. But even within this assessment, there's something called a specially affected state. That is a state for which the resolution of a particular legal question has a higher implication for them versus other states. The paradigmatic example of this, and it comes from an ICJ case way long ago, into maritime delimitation, borders at sea. In this case, the International Court of Justice weighed the practice of coastal states more heavily in its assessment than landlocked states. This makes sense. Landlocked states aren't fighting with each other over borders at sea. And so this idea is really what I want to bring to this context, right? When it comes to collective cyber measures, countermeasures, who are the specially affected states? And in my view, these are small states or states that lack the resources or technical capacity to engage in countermeasures on their own, even though they would be legally justified in doing so, but because of the practical reality of their situation, cannot. And so I think it's really important, as Estonia has already done and some of these other states, to actually issue their national positions on this matter, because this is really the biggest resource we have when it comes to identifying where do states land on what is permissible and what is not in this context. And I think when we look at this, it's also really important to remember that this isn't a sterile environment in a lab. When a state feels it has been attacked, when it feels it is in front of a situation that is threatening its national security, it's not like it's countermeasures or nothing, right? There's another tendency that we have to look at of defining which cyber attacks constitute armed attacks such that a response with force becomes permissible. And I think for these states, when they view themselves as being in a position where they have to defend themselves, there's going to be a tendency to defend themselves with the tools that are available. And so I think even though collective countermeasures are often attacked for being capable of escalating a conflict, they can equally de-escalate a conflict by providing states with a non-forcible collaborative option. And so that's why I think it's really important for states that will consider themselves especially affected, as I'm putting forward, precisely the states that would need help in engaging in countermeasures, to come forth and say their views on this question.
Thank you, Lisandra. And as you mentioned in your paper, many states have come out, in support of collective countermeasures, some of which are, in your view, especially affected states. So please do read Lisandra's paper to find out more about who these states are. Now, Erki, if I may turn to you now. So as we know, Estonia here at CyCon in 2019 issued its first national position, including on the issue of collective countermeasures. And it was perhaps the first state to actually issue an opinion on this. Could you explain to us what Estonia's position was at the time, or maybe still is today, and what motivated this position?
Yeah, thanks. For us, the question is actually simple, because the thing was that 2018, when we started this process of actually deliberating what our positions on international law should be vis-a-vis cyber, then of course the world was quite a little different beast than it is now. But what we tried to achieve was that of course, there was this sentiment of having the national position, being deliberative on it, and we have been, I think, since 2007 and onwards, after those cyber attacks that kind of defined the landscape for us. We have been working closely with the understanding of that we need to be open in how we view international law and cyberspace, what applies, what not, in our opinion. And there is, of course, certain elements of national trauma behind it, because much of small state thinking on international law is driven by their own security, defense, and foreign policy. And for us, international law is a very important element in establishing the Estonian state, and also re-establishing it daily on the international level. And one of our presidents has always said that international law is the nuclear weapon of small states. But what he actually meant was not this mutual assured destruction and all that, but in the sense that for us and similar states, why international law matters to us is that it provides stability, foreseeability, but as well as we have to be mindful of how we develop it, of where we want to be and what we see are the changes on the international level. So in 2018, we had very long debates on the countermeasures, even just talk about the countermeasure as it being something that Estonia could support and apply in certain cases. And after that, also the collective side of it, the collective countermeasures. And I think a lot of the thinking that also Talita just brought out was actually behind it. We saw it at that time in the context of working with our allies. We saw the Lock Shields exercise, different mixed teams. We saw that cyber was a little bit more different as a domain, in the sense that the aid and assistance, which we will come back to, of course, is the aid and assistance isn't really fully, let's say, compatible in cyber, because our capabilities are somewhat different as states. Our capabilities are also usually secret from each other. So we thought that we have to find ways how we can support each other, and collective countermeasures at that time felt like it could be one of those things we could use. And of course, what we thought about was what are the cases? How do we contain it? How do we have a distinction behind it? Our own thinking was more of along the lines of the erga omnes obligations, and if they are breached, rather than the specially affected states. Because we saw that erga omnes obligations are much more clearer in a sense than the specially affected states understanding, because that's a little bit more open to abuse as well. And we are in a region where there is an abusive neighbor. We have also other abusive states in the neighborhood, by way of Belarus, for example. So we were mindful of as well of how do we provide foreseeability of how we want this thing to also develop. And there was an element of deterrence behind this policy thinking as well. At that time, we saw that cyber operations are developing in a way that might be detrimental to very connected states like Estonia, but as well as they could be very detrimental to the states that do not have adequate cyber defenses yet. So how do we balance those things together? And of course, the rules-based international order, we see it also like Lisandra said, that this is a return to legality or a de-escalatory measure, that this is something that we can provide by way of enforcing international law. And it is funny to see in a larger context that in 2018 or 19, this type of thinking was, I'd say, groundbreaking, at least kind of putting these ideas forward and starting a debate. And that's what we actually wanted to have. That let's have an element that starts the debate and let's push the envelope. But since 2022, we've been debating countermeasures on the sanctions, on freezing Russian central bank assets, closing the airspace for Belarus and Russia. So things are now moving at a very high tempo on countermeasures, and it actually might seem that maybe cyberspace is being left behind on the debate on the countermeasures now. So it's interesting to see where we're going, but I'd say that the law, or at least the understanding, isn't really settled at the moment as well. But we try to be as much as a country that kind of pushes the topic forward, and that's been our thinking. And I think that CyCon as a conference is also one of those elements where we can have these debates.
Yeah, and states make international law, right? So if they want to change the law, to develop the law, they have to speak out like Estonia has. So you've touched on a number of important points that I want to, pick up on, if I may, and also discuss with the other panelists. And the first one is, the elephant in the room, and also the title of our panel is about the Russian aggression, right, against Ukraine. And this is one of the current events that has, reignited this debate on collective countermeasures for the reasons that Erki just mentioned. A lot of states have, moved to adopt a number of restrictive measures against Russia, including asset freezes, aviation bans, trade and investment restrictions, and one state has moved on to confiscate the sovereign Russian assets. It's Canada. And so a lot of these measures, at least some of them, they look like collective countermeasures, right? Because these states are not directly or individually injured by the breach, right? And so that could be an instance of collective countermeasures. So if I may ask the panelists, do you think that, and Erki, you mentioned that Estonia's position was motivated by that. It was perhaps along those lines of erga omnes or general interest countermeasures. Do you think that the law has now evolved? And Lisandra, in your paper, you say that the law is really, a new rule is emerging. Do you think we have reached a point, specifically for this kind of collective countermeasures and the general interest? Do you think that we have reached that point where the law has, evolved to permit not indirectly injured states to take those measures? Does anyone want to start? Jeff, can I start with you?
Yeah, I mean, this gets back to a paper that I wrote for CyCon 4 years ago about retortion, where I like to call everything possible retortion, because then we avoid all the difficult legal issues with countermeasures. So, but I think a lot of the unfriendly but otherwise permissible actions could be counted as retortion, and I think some of what has been happening is. But I do agree. I think that we might be pushing the envelope a little bit with some of the acts into having to say, okay, these actually are countermeasures.
Lisandra.
Well, I actually want to quote you. So Talita just wrote a paper on countermeasures that is excellent. I recommend everyone read it. And she raised that actually one of the difficulties is how states characterize their actions, right? And this is a really important point, again, because in identifying norms of customary international law, opinio juris does weigh heavily. And so we can say, oh, well, this state practices this, but then the state says, well, it's this other thing. And it leads us into this really difficult debate of objectively, what is it, and how do we identify what's happening? And I think particularly in this context with Russia, it's really difficult to discern what states think that they're doing and what legal obligations they think they're acting under. And I think, again, especially in this context, it becomes even more difficult because this is an ongoing crisis, right? There is a moral imperative to act, and that makes any sort of assessment of the law sometimes feel inappropriate, right? As you're facing a humanitarian crisis, as you're facing violations of international law, then to be the one in the room saying, well, the procedural elements are this and this, it makes it really hard. And I think, I don't know that we're at an extensive enough practice at this particular moment to come to a really sort of definite conclusion on the matter.
Yeah. Erki?
I agree with everything has been said now, but it's also kind of this discussion of taboos. We have seen during the last 2 years, and we're now in the third year of the war, actually, of ongoing, and everything seems to follow this schematic of or mechanism of breaking taboos, be it on weaponry, what kind of weapons we supply or not, what are the restrictions. And I do see that we have the same debate in the legal sphere as well. And of course, the characterization is one of those things. What do we characterize those measures that we have taken in support of Ukraine? There's also an argument to be made that since Russia is waging a war of aggression, then that's an erga omnes obligation for other states to do something about it. At the same time, we can also characterize it as countermeasures in support of Ukraine, which is also a possibility. But at the same time, we see that in the legal debates, of course, we have these different bodies of lawyers coming together within NATO, in the Chatham House process as well, from the states, from the academia, but as well as within the EU. And there is hesitancy actually to define something as a countermeasure. I would say that's the room isn't 50-50 on that, but it is predominantly, I would say, that there's hesitancy to define something that we are doing, which walks like a duck, talks like a duck, as a countermeasure. But at the same time, I think there's a policy element too, which makes a lot of states somewhat, I wouldn't say hesitant, but at least cautious, which is that you define countermeasures as something that is a response to already a breach or a breaking of international law or the norm, and you take that with the responsibility to breach and break international law vis-a-vis that state. And for a lot of, I'd say, Western countries, that's a pretty high bar to come out and say that I am now breaking international law because you are breaking. And that hasn't been, I think, since 1945, the world that we have tried to live in. I think that explains also these very rough policy debates around countermeasures, because there might be an element of feeling that maybe if I say these things out loud like they are, that maybe I'm becoming the enemy as well. But at the same time, you can say that, well, if they succeed, then there wouldn't be international law or the rules-based order to protect. So we have to do something now. And of course, we will do it as it is, as it's proportionate, as it's reversible, as much as we can. So I think that's where one of those really strategic questions is on this topic at the moment.
Yeah, but the consequences of a state not making its views clear is, misunderstandings, right? And, we have researchers who might misinterpret a certain measure as, being a countermeasure when a state does not intend, as you mentioned, Lisandra, it's, the opinion juris is really important, but, if a state doesn't make its opinion juris clear, then it's open to different interpretations, and we might read into something, into a measure, something that it isn't, right? And so I want to turn back to all of you to ask about the importance of coming out clear, of being transparent, and and we talked about the role of state silence yesterday on a panel on national positions, right? And silence might also have legal implications. So if states don't speak out, they might be missing out on an opportunity to advance the law, to express their views. They might be seen as taking a position that they don't want to take, and also states that keep denying or objecting to these developments might be winning out. So, in your view, what is the importance of making these views clear? If not the state practice, at least the opinion juris. Why is it so important? For example, through national positions. Jeff, if my...
That really became clear to me writing this paper, because there were a number of states that, to varying degrees, addressed collective countermeasures. Some added to the debate in great detail. I'd point to Canada, which said, and I want to make sure I'm accurately representing them off the top of my head, but where they're saying there's not sufficient support right now for collective countermeasures, but they did specifically talk about how assistance and aid would be acceptable, and that I think is a very important distinction. And that sort of thing, getting into the nuance, helps to build the body of international law. So, knowing, I think. I'd like to see more states coming out with that, and the workshop yesterday on international law on statements was very helpful, because I think this is part of just a growing movement to get states to go on the record. So I think more of that will help sort of build norms and expectations.
Yeah, Lisandra?
Yeah, so in that sense, I want to address maybe the hesitancy that some states have about collective countermeasures, and that a lot of the Talon manual experts have as well, right? And of course, The source that's often cited is the 1986 ICJ opinion on Nicaragua, right? And as the title says, it's the case concerning military and paramilitary activities in and against Nicaragua. In my view, this is really a case about forcible measures. The United States took mostly forcible measures against Nicaragua in what it justified as collective self-defense. It put all of its actions under the umbrella of international humanitarian law. Then when the International Court of Justice said, well, Nicaragua's actions constituted an unlawful use of force, but not an armed attack, you can't justify it with collective self-defense, the United States stopped participating in the case. So the court took it upon itself, as it's bound to do by the statute when a state stops participating, to explore other possible defenses that it could put forth. And so on its own initiative, it decided to address countermeasures and collective countermeasures as a possible defense. I think that, again, it was really looking at forcible measures. And so in my view, it's not appropriate to say that it said collective countermeasures are in no sense allowed. There is a paragraph 249, if you want to look at it, where it says only the injured state can take these countermeasures. So let's say we actually accept that view, that only the injured state can take countermeasures. This was a decision in 1986, in which itself the court said that if a state starts to rely on a novel right or legal exception, and enough other states share this, we should think of customary law as being modified by this changing practice. They said this almost 40 years ago. We're in 2024. A lot of states are starting to put forward their opinions, and I think this is really the crux of what's happening. If we want to assess what customary international law is, we have to be able to discern the developments. And so that's why I think it's really important for states to do so, and these national positions are a really great tool for them to do that.
Yeah, Erki, if I may come back to you on this point.
A couple of thoughts. I think we're also at this time in a place in international, which I think looking back in 10 or even 20 or 40 years, I do think we see it as a historical point in time. And we must be also mindful of that whatever we adopt or approach at this time, that it might have mid-term, even long-term effects. At the same time, we must also be mindful of the values that we're trying to protect under international law. So what I'm getting at is that, of course, I think we are creating precedent as nations of how we behave vis-a-vis Russia or Belarus, even Iran, or any other actor that we deem as breaking international law, or at least not following as it should be. But these precedents come in two ways. They can come by way of us acting, or by way of omission, of not doing something. And of course, our position, being very transparent, is that it's better to say what you're going to do and then do it, rather than to have this obfuscation and ambiguity. But I also understand that for a lot of states, and it is, of course, certainly a peculiar argument, that there is a feeling that if we are too transparent in what we're doing, then this might take this constructive ambiguity away sometimes. And that's also something to calculate for. But maybe you are making a precedent that makes us vulnerable in the future. So there's this hesitancy to go too far, but actually taking like step by step and see where this thing goes. And we have heard arguments that if we open this box of countermeasures, if we use, for example, the Russian central bank assets, that maybe there would be claims against us on such things, claims against practice of colonialism, for example. And these different arguments weigh heavily on the minds of states that are also the permanent members of the Security Council, to be very frank, large countries in Europe as well, which have their own histories. So I think we're also trying to help Ukraine being as transparent as possible, but at the same time deal through this historical traumas that we have been inflicting upon ourselves and to others at this time. So there's this identity politics behind it as well. And Jeff also mentioned the Canadian law on the use of those frozen assets and repurposing them and using the countermeasures as an example of it. Estonia our parliament adopted last week our own national law as well on use of frozen assets. And the explanatory note makes it very clear that we borrow very much into our domestic law as well now from international law and the law of countermeasures, because that's the only way to do it. That's the only way to overcome very tough legal obstructions in the sense, for example, state immunity and all that. So we do think that it's better to be transparent in what you're trying to achieve and why and what is the reasoning, and at the same time also be mindful that the law, international law, is always what the states say it is, but as well as what the states act on it. And I think we're seeing more acting, but less saying on what it is. So the opinion juris thing is sometimes very hard to come by. But we might be also at one point at a tipping point where things will be clear that, well, if everybody acts like this, then of course they would accept that this is also the opinion juris.
Mm-hmm. And other states, not just Estonia and Canada, have qualified some of these restrictive measures against Russia or Belarus as collective countermeasures. So Italy, for example, an administrative tribunal in Italy. There's also a court in Germany, or the Attorney General in Germany for those interested. The Court of Justice of the European Union as well, and also the European External Action Service has issued a paper on this topic, coming out publicly and saying that its opinion is that at least some of these restrictive measures, including some in the cyber context, are collective countermeasures. So for those interested, those are some of the legal authorities there. And Lisandra, on Nicaragua, yes. And the other interpretation that is possible, which is the one that I argue, is that the court might as well have been referring to that particular case. So collective countermeasures were not allowed, in that case by the United States, but it wasn't necessarily closing the door. And as we know, the International Law Commission, which studied this topic, back in 2000 and before then, for over 50 years, it was also very divided, right? And there were different views there, and it was so divided that it left the question open. So the door was definitely not closed, right? So that's the important starting point for us. So, if I may, Erki, you mentioned, and also you, Jeff, mentioned the issue of aid or assistance, right? And that's different from obviously taking collective countermeasures. The threshold is a little bit lower. The kinds of measures are slightly different. Why do you think? And Erki, you mentioned that, but if I may go back to you for to delve deeper into this question. Why isn't aid or assistance sufficient to address all of these concerns that have been motivating, this push for collective countermeasures? So, Jeff, if you want to.
Yeah, I fully agree with Erki's assessment that aid and assistance it can help, but when you're dealing with cyber, sometimes it has to be the country that's assisting actually implementing the actions as well. And so I think that there is some room for aid and assistance. And I mean, I think Hunt Forward on a defensive basis is that sort of aid and assistance, which is very successful. But if you want to go the next level in terms of collaboration, I don't know if you could get there just with aid and assistance. And I also think that it's a difficult line to draw when you're talking legally about what's assistance and when does it cross the line over to a countermeasure.
It's very blurry. Yeah. And these cyber operations happen so quickly. Yeah. How are you going to provide the victim state with all the tools that they need to mount defensive or if more offensive kinds of operations in response to malicious acts? It's tricky. Lisandra.
I think as Jeff just said, it's really about this boundary and this line, and where do you cross from merely providing assistance into a more active role. And I think that sort of clarity is actually really important for states as they assess their own possible responsibility when they're engaging in these operations, right? And it's one thing to identify a threat, and it's quite another to counter it, right? And I think, again, these states that maybe don't have the technical capacity or the resources to do so, identifying a potential threat is not going to get them to the place that they need to be in order to counter these cyber operations.
Yeah. Erki, you already sort of like laid out some of these arguments, but if I might push you a little bit more.
It's actually a very tough topic in the conduct of cyber operations, this aid and assistance. Of course, you can have these exercises. The hunt forward, of course, is one of those examples of aid and assistance. But I think this mechanism only works up to a point. And when you really want to affect the opponent and maybe break from the defense to the offense, and even some defensive tools can actually be used in a way that they could have harmful effects if used wrongly. So we're dealing with very specific capabilities where I do think that states can work in this aid and assistance mechanism or a model up to a point in collaborative teams or at least having certain prescribed effects. But there's also this hesitancy to show not to only the opponent, but also your allies of what are the capabilities that you actually have, because these are usually tailor-made. Also, you tailor-made make that cyber capability against different adversaries, different opponents. And if these become very known, even to your ally, then they might not be useful after that. So there's this element that you cannot show the full hand. But on a legal side, there's always this question as well on the legal responsibility, which plays heavily into this. But as well as, and if we look at the Ukraine, then this has been one of the things that NATO members or states that really help Ukraine are tackling with this, that where is the line where you actually become a party to the conflict as well, or co-belligerent, et cetera, et cetera. So these are the things that states in such scenarios really have to work through. And I think on low and maybe mid-level operations, this aid and assistance might work. But if you really want to go into using collective countermeasures against an adversary, of really forcing them back into the legality and into the de-escalation, then I think there will be a national hold on very specific cyber capabilities.
Great. And so the three of you are all aligned and agreeing that this is the right way forward, that more states should come out in favor of collective countermeasures. And you've laid out, some of the policy considerations, the motivations for that, why it can be de-escalatory, for example. But what are some of the concerns, right? What are some of the challenges with that? What are some of the risks? So I've mentioned conflict escalation, which is like the usual thing that people say against collective countermeasures. Is that something that is realistic, or is that not really the case? And what are other concerns that others might have raised against these measures, Jeff?
Yeah, so I think there are very valid concerns about adopting broadly collective countermeasures that it could be escalatory. I think that would, and I fully agree with Lisandra that when you look at the alternatives to collective countermeasures, that could be even far more escalatory. Ashley Deeks wrote a paper for Lawfare, I believe, last year that made this point very effectively. So I think that a way to address that would be the traditional limits on countermeasures. So things like proportionality and limited duration and having the specific purpose of ceasing the internationally wrongful act. So I think all of those things, obviously you need to make sure they're implemented, right? But I think all of those things could at least help address those concerns.
Lisandra.
Yeah, I think one criticism is usually in terms of abuse. And I think this is a criticism that can be made about anything in international law, right? States can abuse a particular notion. You have Russia saying it's in Ukraine for denazification. I mean, we see it, right? And I think that's an important thing to keep in mind. But again, as Jeff just said, countermeasures have limits, they have conditions. And if you are wrong in your assessment, you can be held responsible for that unlawful action you took as a countermeasure if it doesn't actually comport with the requirements that are set in. And I think when it comes to international law, we really just have to be careful about these requirements and to make sure that we are trying to hold states accountable to the limits that do exist. Because when we have alternative solutions put forth that don't yet have any limits into the actions that can be taken under these legal theories, you actually really do enter in this world of possible abuse because there are no legal limits set in yet for what you can do under this theory of justification. And so I think while yes, collective countermeasures could be subject to abuse as much as anything else could be, and it's really our job as an international community to keep track of what states are doing in the name of collective countermeasures to make sure that they're actually respecting the limits that are already set forth.
So it's best to use the proper law and the proper limits then to operate in the gray zones. Erki.
Well, everything has been said already, but not by everyone. So I agree. The limits, that's one of the concerns of how do we constrain it, to limit it, but as well as this escalatory aspect of it. That's, I think, something that the states are very mindful of at the moment. And in my personal opinion, I do see that there is this there's this risk, or at least that's my understanding when I've been talking to with the other states as well, and the representatives, is that there's this feeling that if we go along this line, what's the point of the UN Charter system after that? Maybe everybody that wants to say that that brings back this abuse argument that if something happens, I can always take a countermeasure, maybe find a couple of allies as well, and that really takes away the monopoly of the UN Security Council, that takes away the monopoly of the UN Charter system as well. And these are heavy topics. These are the things that we must be mindful of, because that's really what we do not want to achieve, but that's obtainable, finding this positive momentum is that when we define the really understandable and foreseeable limits on the use of countermeasures. And I'd say from an Estonian perspective, which is not, let's say, the government position, but erga omnes obligations are one of those really defined limits. Of course, you can also have abuses on them as well, of how do you define them. But with Ukraine, you can really make an argument that there's a strong case for erga omnes obligations there, because the General Assembly has deemed that there's an aggression going on, that Russia is responsible for it, that they have to compensate for the damages. We've seen grave human rights abuses being conducted. So if we limit to very strict cases of where we would not allow just to enjoy the problem, but actually deal with the problem, then I think we can overcome the constraints, but also be mindful of the risks and have this balancing act.
Yeah, and many states have raised the Security Council argument back in the International Law Commission debates, right? Many states said, well, if we allow states to take collective countermeasures, that's going to undermine the role of the Security Council. But we all know how the Security Council is now with the veto, and Security Council action is not the only way to enforce international law, and that's why we have countermeasures, right? And just one final question from me to the panelists before we go to the Q&A. Do you think that these developments on collective countermeasures, and I think, Erki, you touched on this point, should they be limited to the cyber context, to cyberspace? And we spoke about this phenomenon in the workshop on national positions, right? What happens in cyberspace doesn't really stay in cyberspace. It has, effects, domino effects in other areas of international law. So what is your take on this, Jeff?
So I think that cyber has really illustrated why collective countermeasures are so important, but I agree that it would be very difficult to cabin this just to cyber when you're dealing with things like asset freeze that might have a cyber relationship but are not what you would traditionally think of as cyber. So I think that if there is a broader acceptance of collective countermeasures, we couldn't just limit it to cyber.
Yeah, Lisandra.
Yeah, I agree. I mean, I think even just starting from the basics, countermeasures don't have to be in kind, right? And so you can really, as a state, look at what you think is necessary and proportionate to get the breach to cease, right? And so I think that's something that's important to think about. However, having said that, I do think that maybe when it comes to the specifics of how to conduct countermeasures, that then there can be some aspects that are limited to the cyber context given its immediacy and maybe covert nature, but that would really be into the details of what makes an action lawful. But I think the concept overall, it's going to apply to multiple situations.
Erki, a final word.
By way of policy, I do think that states would not limit themselves in their responses only to cyberspace, because even the Tallinn manual debate when we had it, that if there's a cyber attack, you have to respond in kind, and there's the consensus that no, you actually have to see what is your most legitimate and proportional response to it. And I do think that this applies here as well, that of course one can make an argument that if we limit countermeasures to cyberspace, then of course that gives it a more concrete foreseeability, or at least limitations on it. But policy-wise, I do not see states accepting that argument, and they won't go down this road.
Yeah, it would be a bit limited, right, to keep it there, especially in light of what's happening with Russia, Ukraine. Yeah. Now, thank you so much. A lot of food for thought there. So I'm going to open up the floor for questions. Kubo. Actually, I'm going to take a couple at a time, so that's going to be easy. Tomo, there. I'm going to go back to the other side. Kubo, and then Tomo. And then the gentleman, yes, the gentleman here. And then I'm going to go to the other side in a minute.
Thank you, Talita, and thank you to the panelists for a really rich and fascinating discussion. One thing I really wanted to appreciate for all three of you is how careful you have been about stating, what the law is, and that your arguments pertain principally to where the law might be evolving. And so I think that's a very important distinction for today. My question is for Lisandra, for a part of these compelling arguments that all three of you are making about the direction of the law. So for you, it's this question of specially affected states, right? And so I was thinking about this and trying to get my head around, this argument that those states that are small, that they don't necessarily have the capability, and that might need help, that are in need of powerful friends, are the specially affected states. And your example of coastal states is an interesting one, but I don't know if it's so persuasive, because I'm thinking that countermeasures are a little bit more like maybe investment relations that are more a two-way street, right? So when we talk about specially affected states in economic rules, we look not only at what the investor states are doing, but also states in which investment is received. So for countermeasures, I think it's also like that. So I think we should be careful about saying specially affected states are only those that might benefit from collective countermeasures. And my counter-argument to you would be, we need to also have a look at the practice and the opinions of those states that might be on the receiving end of these countermeasures. And of course, it seems to me that that somewhat weakens the case made on the basis of specially affected states. So I would wonder what your reflections would be on that. Thank you.
Let's take Tomo's question, and I'm going to take three at a time, and then the panelists. Tomohiro over there. Yeah.
Thank you. My name is Tomohiro Mikanagi. I'm legal advisor of Japanese Ministry of Foreign Affairs. I also thank Talita and all the panelists for very interesting discussion. And actually, the discussion, content of the discussion was very familiar as a legal advisor advising the government in relation to the cyber activities and also Ukrainian asset utilization. My question or comment is that you are talking about countermeasures here. These are secondary rules of international law, but it is obviously closely linked to the primary rules of international law. We discussed the issue of primary rules yesterday in the workshop on the national positions. And I pointed out that the threshold for the violation of sovereignty is very ambiguous. And I think the hesitation of states to publicize their position on the corrective countermeasures have many reasons. But one reason, a very strong reason, is the ambiguity about the primary rule. If you talk about countermeasures, you imply you are doing something wrong. So you don't have to explain your position on countermeasures if you are doing something allowed under international law. If you panelists have any views or positions about the primary rules like violation of sovereignty itself, there are some reference to low, medium, and high kind of explanation. That's very interesting. That fits my image. The low intensity action might fall below the threshold of violation of sovereignty. Maybe the high intensity action might go beyond the threshold of violation of sovereignty, but medium thing. Well, what do you mean by medium? But that threshold issue is very important in discussing countermeasures. So I hope you could have some comment on this issue.
Thank you, and gentleman over here.
Thank you. Lieutenant Colonel Massimiliano Signoretti, Joint Operations Cyber Command, Italy. I would refer to Dr. Erki Kodar remarks, and I think he hit the core of the issue. So my question is, are we more assisting to an evolution of the interpretation of the of countermeasure or to collective countermeasures? Or perhaps we are assisting to the implication of the erosion of the principle of neutrality. He mentioned the Russian aggression towards Ukraine, and I think this is the shift of the paradigm in this case, because we have obligation towards on states, you see, not to assist the aggressor. We have in mind, and Dr. Kodar mentioned it, we had in mind the UN Resolution 3314, paragraph 1 and 3, specifically, so states are not asked to be impartial towards the belligerents, but they are called, you see, to assist the victim of the aggression and to intervene against the attacker. So my question is again, are we assisting to the evolution of the countermeasures institutes, or we are assisting to the implication of the erosion principle of neutrality?
Very interesting question. So we have a question about the scope of specially affected states by Kubo and the distinction between lex ferenda and lex lata. We had Tomo's question about the relationship between countermeasures as a secondary rule of state responsibility and primary rules, in particular sovereignty, and the question about the relationship between countermeasures and rules of neutrality, or whether we're seeing an evolution in the rules of neutrality. Lisandra, I'm going to start with you, just because we had a question on about your paper.
Yes, thank you, Kubo, for that question. I did actually struggle with that as I was writing this paper. And I wanted to go with coastal states example for the non-lawyers in the room. I think it's much clearer. But in the paper, I do actually talk about foreign direct investment as an example of how to address specially affected states. The International Law Commission uses this as an example. And in their example, if you look at it, it's both the states that are receiving the assistance and then the states that are capital exporting states. And so in my view, that would mean the states that actually want to engage in collective countermeasures with these smaller states, right? You're not necessarily looking at the practice of states in foreign direct investment who are not investing, right? It's the ones that are actually lending this assistance whose practice you take into consideration. So in that sense, in my view, if these larger states were to then engage in the collective countermeasures with smaller states, I do think that they would also be specially affected states in that sense. But I feel like The states who wish to not engage could simply not engage, if that's clearer. We can discuss later.
Jeff, any thoughts on any of the questions?
Yeah, I mean, I think so. The sovereignty issue is very important, and as I was writing the paper, I had to be careful because obviously there are different views as to what constitutes an internationally wrongful act, and especially in terms of the sovereignty questions. So I think that that's a very real question because it depends on which state's position you're taking. Now, not that everything goes back to retortion, but I will say that some of it does, which is if you're going to take the position that setting a much higher bar for what constitutes an internationally wrongful act, then that also leaves the door open to more unfriendly responses that you could classify as retortion.
Yeah, the two issues are interrelated, right? The more rules you have that might be breached, then the more opportunities or chances to take countermeasures you have, and so on and so forth. Erki, any thoughts on any of the questions?
A lot of thoughts, but I do have to make a clarification that I'm thankful for the promotion to the doctor, but I'm not a doctor. I appreciate it. On the primary rules and the secondary rules, I think that's more of a distinction that is made within the academia rather than within the practice of stateside, I actually even say. Of course, it is an important element of how we see the, let's say, the hierarchy of norms and different concepts and principles. But I do see that we are at this point where the primary rules of international law are under a tremendous strain. And the question is, will this rules-based order actually survive? So we also have to use the secondary rules to enforce even the primary ones, to make a bridge along them. And on sovereignty, I really have to, when we have gone through these different state positions on cyber and how they see international law within cyberspace or cyber operations, one thing that really pops up is that even among allies, we view sovereignty quite differently. Even within NATO and EU, there are states that see it as more of a principle and others as a norm. But if you would come around this let's say, part of the world and ask whether you want to be a principle or do you want to be a norm, then of course we would default on the norm because we have seen that in principle we were sovereign. We were of course occupied for 50 years. We existed de jure, but not de facto. And after that, we very much prefer de facto existing, so to say. So I think that settles the debate for us on sovereignty, what it is. But on neutrality, that's a fascinating question. Yeah. Whether what we are seeing is now also re-establishing the rules or redefining the law of neutrality. And I do think that this was a question already on cyber operations 10 years ago. How much can one actually affect the neutral states through different cyber operations if they traverse through it? Or how much can you actually provide aid and assistance or not? What are the obligations? But if you look at state practice, there's of course certain self-policing in the sense of how much would you want to be involved in a situation. So I do think that neutrality is maybe evolving, but we're not actually understanding where it is evolving to. Even if you look at traditionally neutral states like Switzerland, Switzerland has aligned itself with the EU sanctions, for example.
That's true.
It works closely with the G7 reposition commission or what it is. So I think neutrality at this time is actually what the state says it is and what its position is vis-a-vis a certain situation. So fascinating times, no clear answers. As lawyers say, it depends.
Yeah, maybe that will inspire someone to do a PhD thesis on that. And on
not me.
on the Lex Lata, Lex Ferenda question, I think that's a very important distinction, Kubo, which both Jeff and Lisandra make beautifully in their papers. And I was very glad to see that, because that rigor is very important, and it's not something that we see very often. I'm going to go to the other side here. I'm going to take 3 questions here, gentlemen here at the front, and then 2 at the back. Chris and the other gentleman there.
Thank you
Thank
for
you.
giving me. Does it work? Oh, yeah. Thank you. I'm Alexei Tkachenko, National Security and Defense Council of Ukraine. First of all, I would like to thank all the countries for all the support providing to my country during the war. My question and comment would be, to what extent Russia or any other aggression should go in the cyberspace or in any other domain, like the rocket which was in the airspace of Poland, the NATO country, actually for the minute, and nobody reacted. So to what extent Russia should go in cyberspace for the countries to get awakened and at last do something and accept those countermeasures? Because Russia is a cyber aggressor, not only against Ukraine, but mostly against the world. Court pipeline in the US, elections, hybrid aggression against the European election in this year. But actually, it seems to me that everyone is thinking, well, okay, they didn't kill anybody by cyber attack, so let's do it with it. Let's live with it further on. And Russia is present in many international cyber organizations. In UN, it's doing its resolution on informational security. Russia and informational security, it's very funny. In OSCE, it's present in the IWG working group still, and addressing to norms in cyberspace which it doesn't fulfill. So what should have happened in order to countermeasures against the aggressor should be done?
Okay, so what should be done against Russia? So we've got 2 more questions in the back. Yes.
Hi, Chris O'Meara, University of Exeter. Just like also to thank the panel. And my question really is just to pick up on something that has been alluded to in a couple of presentations, which is the relationship or the interaction between collective countermeasures and collective self-defense. And it seems to me, particularly when we're talking about things like aid and assistance, which potentially takes us into use of force territory, potentially justifying self-defense as a legal justification. So how do you have any reflections on how states moderate that, whether they deliberately are ambiguous, perhaps there's some lines being blurred? I'd just appreciate your thoughts.
Yeah, and there was another question there.
Hi, I'm Martin Libicki, U.S. Naval Academy. It's my understanding that countermeasures work this way. If you do X, I'm going to do Y until you stop doing X. And I can see how that works if X is continuous or periodic. How does it work when X is neither continuous nor periodic? How do you figure out that X has stopped?
Okay. How do you know when someone has stopped the internationally wrongful act, if I understood correctly? So we've got a question about what should be done against Russia, because what has been done doesn't seem to be working, if I understood correctly. Then relationship between collective countermeasures, aid or assistance, and self-defense, and the other one about timing of the internationally wrongful act that triggers a countermeasure, if I understood that correctly. Jeff.
Yeah, so for the question about Russia, I think that I would hope that what's happening with Russia would make a better case for a broader acceptance of collective countermeasures. I don't know if that's necessarily happening. That's why it would be nice to see more national position statements on that issue. In terms of the self-defense versus countermeasures versus aid and assistance, I think that, and as I'd said earlier, I think that if you look at collective countermeasures as a way of avoiding rising to the level of self-defense and preventing that escalation, that could be useful. And in terms of knowing when the internationally wrongful act has stopped, I think that's, especially for cyber, that's going to be difficult. I think it also might be going on for a long time. We see that with the whole concept in the US of persistent engagement, the idea that we are continuously engaging the adversary. So yes, there are those limits, but I also think that a lot of these threats will be ongoing.
Yeah. Lisandra?
I think actually the first two questions pair really well together because part of this is the debate of does this constitute an armed attack such that self-defense is appropriate and we enter into the world of international humanitarian law, or is this sub-threshold such that forcible measures are not allowed? And I think that this concept of collective countermeasures is really meant to try and address when something does not rise to the level of an armed attack, and to have states have an option, in peacetime, as it were, to effectively counter some of these cyber attacks. And I think that's really why collective countermeasures has become a discussion in the cyber domain specifically, because as well, there is a lively debate on when a cyber attack constitutes an armed attack or not. And then, some states don't want to express what that red line is. And so I think if you have an option such as collective countermeasures, you can engage in an effective resource without necessarily giving away where your red line is as you see fit.
Yeah. Erki?
Very interesting questions, actually, because a lot of these things boil down to the threshold again, like was just alluded to. I think on the countermeasures, we try to be as below the threshold of the use of force as we can, because if you go above it, then that's already a new set of playing field, new set of rules. And your aim is with the countermeasures actually to force the opponent to stop its illegal behavior. So I'd say that countermeasures aren't, let's say, a hammer for every nail. We have to be mindful of where we use them. I think we have to be mindful of using them on, let's say, issues and breaches where we can really have an effect on the opponent, on the adversary that we're trying to achieve. But of course, on the airspace incursion, nothing prevents Poland actually acting in its own self-defense and shooting down those missiles. The question is, do they have the exact time when it's only flying through, let's say, 30 or 40 seconds? But as much as I know that this is a thing that the Polish are now thinking about, that we don't want that our territory is being used for such acts. And of course, the cyber and hybrid operations, cyber operations, I think, are ongoing constantly. So the question is what you actually pick out that you want to respond to with countermeasures. And on hybrid operations, well, I think we're sometimes really focusing on a separate issue or a separate problem without seeing the full picture of what is being dealt against us. And the thing is that what we are experiencing now with hybrid operations, also against Estonia, the removal of these light buoys on the border in the waters, as well as there have been attacks against property of the Interior Ministry and the editor of a daily newspaper. We are also below the threshold of somebody getting really hurt. And if we move along these lines, somebody really might get hurt. So what really works in these situations is showing resolve, showing determination, but countermeasures might not be the tool to address that. It might be something else in our diplomatic or legal toolbox. But Martin's question was really interesting because intellectually and operationally, you can have two different, let's say, situations. One where something has stopped and already a new thing has happened on top of it. And how do you respond to the first one without implying that you're also acting against the second incident? But as well as with countermeasures, there's also an obligation of notification that you are now employing countermeasures against the opponent. So that's maybe one of the tools that you can, let's say, manage risk by saying that I am responding against this situation that happened against me or another state, if there's consent or collectiveness behind it. And these are countermeasures that we are using against you. If we deem the situation to be rectified. The situation has been resolved, and we will also draw down the countermeasures. Let's say, taking an example of the EU and the G7 sanctions, there actually isn't a predefined end state of, if we deem them as countermeasures, there's no predefined end state of when the sanctions would be drawn down. Because we haven't defined the end of the sanctions. But that's something that might actually fall into that sentiment that you alluded to.
Yeah, and on this point, there's also, as we know, countermeasures are responses to previous acts that have already happened, right? They are meant to induce the responsible state to stop or repair the wrongful act. But there are certain operations, especially in the cyber context, that are so close in timing that sometimes they're part of the same operation. So if you're responding to a subsequent operation, it's not like you are preemptively taking a countermeasure, but you are addressing a single operation that is ongoing or continuous, like a distributed denial of service attack. So that's possible, especially in the cyber context. And another important thing to bear in mind on this question is that even if the wrongful act has stopped, a countermeasure might still be taken to make sure that to induce the responsible state to comply with its obligation to repair the harm. So that's not the end of the matter, right? So if you caused injury, if you caused damage, you still have an obligation to repair, right? And that's something that is happening in the context of Ukraine. Many violations of IHL have ended, or human rights violations, but there's also the reparation side of it. So timing is really important there, but we mustn't just think about the timing of the original unlawful act. There's also the reparation point. And Chris, on your question on self-defense and use of force, that's also very interesting because it made me think of this argument, that by aiding or assisting states that are involved in the armed conflict, you're also a co-belligerent, you're part of the armed conflict. And there's also the flip side to it that, if you take the view that you are a state that is injured by the aggression, and so you are entitled to take countermeasures as an injured state, you might also be implicitly acknowledging that view that you're a co-belligerent in that conflict. So the two questions are closely connected, and states need to think carefully about the kinds of arguments that they make so as to avoid, misunderstandings about the positions that they're taking. So I'm going to go back to the audience. Any more questions on the left side? No? Any more questions? Yes, in the back.
Hi, sorry. Rick Amorosi from United Kingdom Strategic Command. Just building on that comment about, to some extent, the co-belligerency point you just made, and Mr. Kodar's point about communicating that you're taking countermeasures. The kind of states that might be the supplies of the countermeasures to the states that need them, I think tend to be the kind of states that don't like to talk about the sort of more offensive cyber capabilities and their use of them. So do you see that, is there therefore a risk that you are very unlikely to see states declaring that the sort of state practice? And then even worse, because potentially discussing that you might be intending to take countermeasures theoretically by stating a position increases your chances of attribution. Is that also likely to mean that those kind of states are unlikely to come off the fence, and therefore the kind of law you're hoping we will start to describe the norms of is unlikely to ever happen because the very states that would supply them are unlikely to want to talk about them?
Any thoughts on this, Jeff?
Yeah, so continuing my disclaimer that I only speak on my own behalf, I fully agree. I think I think there are a number of states, and I think that's at least a very real possibility of the reluctance for more states. I mean, we have many more states taking general positions on countermeasures than we have taking positions on collective countermeasures, and obviously there's no way to know for certain, but I think that's a very real possibility.
Lisandra?
Yeah, I mean, it's really difficult, especially if you think about the states who would supply or who would be the ones called upon to assist. They're obviously incredibly important. You can't have collective countermeasures if no one's coming to collectively help you. And so I think their positions are really important and should play into this assessment. But if they don't ever speak out, then it's really difficult to know where they stand, how this law can develop.
Exactly.
And they are these important players. And so I think there's a tough balance there whether to decide what to do. And I think in that sense, it's really important to remember that, at least my understanding of what we're arguing for, is the legal permissibility of collective countermeasures, not the obligation to provide collective assistance. And I think that's a really important point here, that the law that is developing is simply, as I view it, that this is a possibility, but it is not an obligation. And if you as a state don't feel comfortable coming to participating collectively in countermeasures, that the law is not going to obligate you to do so.
Yeah. States have an obligation to do measures to try and stop, for example, a violation of the prohibition on the use of force, but not necessarily by taking countermeasures, right? Erki.
I agree fully with Lisandra that it's not an obligation that you have to take countermeasures. It's a possibility. It's an opportunity if you deem fit as a nation to go along this route. And I think there is also a point to this argument that maybe states have a feeling that if they predefine collective countermeasures, let's say, too specifically or too openly, that they might feel that public opinion or any other measure would actually try to force them to go along this line, that if there are these types of situations, as you have defined as a state, then you should respond. And this is a situation that needs responding, and this is our policy. Why aren't we doing something? So I think we have a much more hesitancy on the side that let's not define it too far. For us, even if it's not a full obligation, it's you may go along this route, but still keep your hands a little bit less tied by other, let's say, policy functions or other tensions that may arise from this.
Thank you. Any more questions from last chance? No? Otherwise, I'm going to go back to the panelists for any final thoughts, takeaways. What's next? What do you think is going to happen in the future? What are your main takeaways about what's going on? Any recommendations? Any final thoughts, Jeff?
Yeah, I think one really interesting thing that's come out of this is the distinction between legal positions and practice. And obviously, we're not going to know exactly what the practice is, but I think things that might be justified as collective countermeasures could be occurring already. And I think it's important for the legal positions to sort of take...
Clarify.
Yes.
Lisandra.
Well, I think, as I said in my paper, I think it's really important for states to come out with their national positions, and you all are actually working on a handbook and a guide for states to do so. So that's an incredible resource that's forthcoming. Not every state has the capacity to really engage in these really difficult and detailed questions. And so I think the more that also states can assist each other in addressing these difficult legal questions, especially, again, these states in the global majority and states that don't have the resources and capacity, that's a really important space for collaboration as well.
Yeah. And many states that have objected to collective countermeasures, and countermeasures generally, they come from the global majority. And, there are questions about economic inequality as well, but there's also this question of the knowledge gap, right? Mm-hmm. So we do need, better knowledge exchanges to make sure that these states understand what's happening, the stakes, and, form their own positions on this. Erki.
Well, in 2019, somebody mentioned countermeasures. It was, oh my God, what is this? 2024, we're almost talking about as a thing that's already happening. So I think in 2029, in 5 years' time, we might have broken along this route many other taboos as well. And maybe we're talking then already of what is the practice of countermeasures for the past 5 years. So I'm hopeful. Things are moving quickly in the right direction, but as always in the international law, you never know. And let's see what the states think about all this.
Yeah, the law is in flux, and it is the responsibility of states, for those who are legal advisors, here to speak out, to make their views seen and public, so that for us scholars and researchers of this topic, so that we can make sure we capture the state of play accurately without any misunderstandings. Thank you so much, everyone, for being here with us. us in this fascinating discussion. Please join me in thanking our panelists for their presentations, their thoughts, with a round of applause.